Let me do a quick orientation to this web room and then have our presenters introduce themselves before we jump into the content this morning. So, a couple notes here. Chat pod, obviously you are finding this. Again, we do have you registered. You don't have to type your name and county in the chat box. If you want to send a private chat, you see that little plus sign at the top of the chat box. You can send just a private chat to presenters or hosts that will come to us here at UNC School Social Work and our presenters. Otherwise, of course, you can chat with everyone. This will be your way to communicate your questions to our presenters today. So please use this chat box as we go throughout today. About those questions. So we're going to monitor them. As you're typing your questions in the chat box, our presenters are going to try and keep track of those. If they're able to, they'll answer them in the chat box or draw their attention to it within the presentation themselves. And we have some time set aside at the end of the presentation to try and address any remaining questions. Also, there's a follow-up document. So we're recording this webinar and your questions. So any questions that are asked, we do post a follow-up document of all the questions asked and then all the answers that goes with the webinar recording. We will also post these slides to go along with that. So you'll see the direct link to where you will find all of our recorded webinars there. If you wanted to click on that, it'll take you right there, of course. You can access it through NCSW Learn. Other way to get our attention, you've got some icons there on your top toolbar. So if you just drop down on that, you can, of course, tell us to speak up or give our presenters a round of applause. We do have, again, over 400 people registered this morning. So you do not have that availability to use microphones. So you won't see the microphone option. Again, use the chat box if you have any questions. We'll look for those. So here's our goals for the webinar. At the conclusion of this webinar, we hope you will know how to screen reports, maltreatment on licensed foster homes, understand the notification process for CPS assessments on licensed foster homes, be able to identify the differences between a CPS assessment on a licensed foster home compared to other CPS assessments, understand regulatory and licensing's role in CPS assessments on licensed foster homes, and understand the process and importance of foster home revocations. Once again, I'd love to welcome all of you to today's webinar. I'm Rick Seckman. I work with UNC School Social Work, the Family and Children's Resource Program. We do have support from Philip Armfield. Philip is monitoring the chat in case we have any auditory issues. He'll be responding and following up with you about that. And our presenters, I'll allow them to introduce themselves. We have Mary Torr from the Division of Social Services and Assistant Attorney General Maria Lattimore from the Department of Justice. Mary, can you jump on the mic and introduce yourself?
Hello, everyone. My name is Mary Torr. I am the policy consultant for regulatory and licensing with the state. I was previously a foster care social worker with Wake County Human Services and a foster care supervisor in Franklin County.
Thank you, Mary. And Maria, can you jump on the mic?
Good morning, everyone. This is Maria Lattimore. I'm an Assistant Attorney General, and I represent the Department of Health and Human Services, the North Carolina Division of Social Services. Prior to coming to the DOJ, I was a attorney for legal aid throughout the Eastern North Carolina, and prior to that, I was a social worker. So I look forward to talking with you guys this morning.
And thank you, Maria. All right, to get us started today, Mary is going to discuss a few case scenarios. So I'll have Mary jump on here.
All right, to set the stage for our webinar today, I'm going to talk about two different cases. Case one is an 8-year-old boy named Clyde who was placed in a licensed foster home. During visitation with his parents, Clyde told his parents and the social worker that his foster mom had hit him on the back of his legs and his buttocks when he didn't listen. The foster parents and social worker immediately checked Clyde, but no marks or bruises were found on him. Clyde was then removed from the foster home, and afterwards a CPS report was made on the foster parents. The report was accepted and was unsubstantiated. Regulatory and licensing was never notified that there had been a CPS report on the foster home, and they were not notified that the case had been unsubstantiated. So then we're going to fast forward for our second case scenario, and we're going to fast forward about 6 months. So Thelma and Louise are 3-year-old twins. The twins had recently entered foster care and were placed in the foster home that Clyde had left 6 months earlier. Thelma and Louise were not yet potty trained and attended daycare. One morning, the daycare worker was changing Thelma's diaper and noticed that Thelma had marks and bruises on the back of her legs and buttocks that were not present the day before. The daycare teacher immediately informed her supervisor, and a CPS report was made. This case was substantiated. So please keep these cases in mind throughout the webinar, and we will actually visit these case scenarios at the end of the webinar.
Thank you, Mary. And we have some polling questions for you. We do have several opportunities for polling questions built into today's presentation. Let me take you to our first. So what you should see here is our first polling question. Please respond to this. You'll see there are 3 choices here. A teacher has noted that an 8-year-old boy has been falling asleep in her class every day for the last 2 weeks. When asked, the child said that his parents have been fighting every night and his dad has hit his mom. The parents are also licensed foster parents, but do not have any foster children living in the home. Would this be screened out, screened in as a family assessment, or screened in as an investigative assessment? So you'll see your 3 choices there for screen out, family assessment, or investigative assessment. Once we see that we've got a number of you responding, we'll share the results there, and Mary can go over the appropriate response type. It looks like we do have almost 300 folks here in the room, and I do see it moving quickly. All right, let me share the results here. So you should be able to see the majority of you so far, is it still moving, have selected family assessment. Almost 70% of you are selecting it should be a family assessment. Screen in for a family assessment. Thank you. I'll bring us back to the slide so that Mary can dig into the appropriate response type.
All right, thank you, Philip. So the correct answer for the polling question is investigative assessment. So after a CPS report has been accepted, counties have to determine and assign the appropriate response type to the report. The response type for traditional CPS assessment can be investigative or family, and the response is based upon the allegations in the report. But if a CPS report is on a licensed foster home, the report must be assigned as an investigative response type. If the CPS report alleges abuse, neglect, or dependency by a foster parent on a foster child, the response type is investigative. If the CPS report has allegations of abuse, neglect, or dependency by a foster parent on a biological child, adoptive child, or child that the foster parent has custody, guardianship of, the report must be assigned as a response type as investigative. If there are no current foster children in the licensed home, the CPS report must still be assigned as a response type as investigative. A licensed foster home always requires the response type as investigative, no matter what the allegations are or who the alleged victim is. If a CPS report was assigned a response type as family assessment, and the assessment worker discovers that the family is a licensed foster home, the response type should be changed to an investigative response. And the Regulatory and Licensing Office is available during regular business hours if a county ever wants to check to see if a home is a licensed foster home.
All right, so we have the opportunity for another knowledge check. Let me bring us back to our polling. And you should see a second question here. When should you notify regulatory and licensing of CPS involvement with a licensed foster parent? You will see your choices are when you substantiate the allegations of maltreatment at the beginning of the CPS assessment. You're not required to notify regulatory and licensing of CPS involvement, or both A and B. Take a moment. Just select the correct response. You should see that on your screen. Don't need to use the chat box. And that way it'll give our presenters a good readout of what the percentage is in the room. It's a little bubble right next to A, B, C, or D. Click on your choice. It looks like we've got a good majority of that have responded. I'll go ahead and show the results here. You will see, according to the polling question here, about 88% of you said both A and B. So Mary's going to discuss appropriate notifications. Let me bring us back to the slides.
All right, so the correct answer is D, when you substantiate the allegations of maltreatment and at the beginning of the CPS assessment. While D is the correct answer for this question, we will also discuss the other times that regulatory and licensing need to be notified of CPS involvement with a licensed foster parent. So when a county receives a CPS report on a licensed foster home, there are two notifications that must occur specifically because the report is on a licensed foster home. The first notification that you will make is to the agency that supervises the foster home. This notification can be verbal, but should occur within 2 hours of the CPS report being accepted. A supervising agency can be a county DSS or a private agency, and their role is to work with the licensed foster family. Every licensed foster family is required to have a supervising agency. Some of the work that a supervising agency does with the family is to work with the family to become licensed and relicensed every 2 years. They also make placements with the foster family. They complete home visits, ensure the children's needs are being met, and they support the foster parents. And this is just a very brief overview of the supervising agency. In most cases, the notification to the supervising agency will occur before the assessment is initiated by the assigned CPS worker. Typically, the supervising agency will contact the foster parents to inform them that a CPS report was made and accepted. It is not unusual for this to occur prior to an assessment worker beginning their initiation. If it is imperative that the foster parents not be notified of the CPS allegations prior to the initiation because of the type of allegations, be sure to convey that to the foster home's supervising agency when that notification is made. The second notification is to the licensing authority. In North Carolina, this is the Regulatory and Licensing Office located in Black Mountain. Regulatory and licensing must be notified within 5 days of a CPS report being accepted on a licensed foster home, if a CPS report on a licensed foster home is screened out, and at the completion of the CPS assessment. counties must complete the DSS 5282 and fax the form to the Regulatory and Licensing Office. And I am just pulling up the newest 5282. This was just recently updated, and the county should now be using the newest form. At the top of the form here, you will see the contact information for DSS, DHSR, and DCDEE. DSS will receive notification of all CPS reports on licensed foster homes, licensed therapeutic foster homes, level 1 group homes, and maternity homes. DHSR will receive notification of any CPS reports that are on mental health facilities. This would be any leveled group home, including PRTFs. And after we finish reviewing this form, I will actually show you the link for the DHSR website, which I highly recommend everyone save the link. And this is a way that you can look up facilities by county, by name, or both. And DCDEE is the one who receives notification of any CPS reports on a child care program. So the first box up here, you would indicate if this is the initial notification of a CPS report or notification of a case decision. The initial notification is sent for reports that are screened in, screened out, and at the and then the rest of the first page is then completed, whether it is the initial notification or the case decision notification. If you're unsure of who the supervising agency is or the licensing ID, of course, you can contact the Regulatory and Licensing Office and they can assist you with that information. So on page 2, we have our initial notification, and the first half of this sheet will be filled out if you are notifying DSS that there is a CPS report. The bottom part, the case decision notification, is completed when you are notifying Regulatory and Licensing of the case decision. And this is the link for mental health licensure. And what you would do is you can put in all counties, you can put in your specific county, you can type in the facility name, and I'm just going to pick a county. And this would be a list of all of the group homes and mental health facilities that are licensed by DHSR in Cabarrus County. For the DSS 5282, please note that there is a list of documents that do need to be included in the case decision notification to DSS. Let's see, the requirements for CPS notification on licensed foster home can be found in 3 different locations: North Carolina Administrative Code, the North Carolina Cross Functions Manual, and the North Carolina Assessment Policy Manual. Administrative Code 10A NCAC 70A.0105 states that the director shall make diligent efforts to locate the alleged victim or children until such efforts are successful or until the director concludes that the child or children cannot be located. Diligent efforts shall include, but not be limited to, visits to the child or children's address at different times of the day and on different days, and all efforts to locate the child or children shall be documented in the case record. The Cross Functions Manual states that all children in the home shall be considered to be victim children. This includes biological and adoptive children, children that the foster parents have custody or guardianship of, and children that are placed in the home for foster care. This is especially important to remember when completing these types of assessments because it is not unusual for a foster child to be moved when a CPS report is received. And some of the reasons that a child would be moved include the nature of the CPS allegations, if there was physical injury or medical care needed. The supervising agency has a policy to move children when a CPS report is made on a foster home, or a foster parent may request that a child be moved. Every child named as a victim must be seen even if the child is no longer living in the home, and all assessment activities must be completed even if the child or children have been moved from the home. And our assessment policy manual states that face-to-face interviews with parents or primary caregivers with whom the child resides must be conducted the same day the child is seen, or there must be documentation to reflect diligent efforts made or rationale for delaying the interview that does not compromise the safety of the child. Face-to-face interviews with non-primary caretakers known to be living in the household must be conducted within 7 calendar days of initiating the CPS assessment, or there must be documentation to reflect efforts made. During the initial face-to-face contact with the parents or caretakers, the county child welfare worker must discuss the allegations and communicate that the CPS assessment must be completed within 45 days of the date of the report. A home visit where the alleged victim child resides must occur on the same day as the victim child is seen, even if the contact and interview with the child occurs in a different location, occur at least once a month with the child in the home during the CPS assessment, and include observation and contact with every child living in the home. When the child or children are not interviewed during the initiation, the county child welfare worker must continue to make efforts to interview the child or children, and these interviews must be conducted as soon as possible and prior to the case decision being made.
All right, we have the opportunity for our third polling question. Let me take us there. Get rid of this one, and you should see number 3. Who makes a case decision when the CPS assessment is on a licensed foster parent? So you see the bubbles available that you can select. The state, and county make the case decision together. So you got 3 choices there. Who makes a case decision when the CPS assessment is on a licensed foster home? Click on the polling question response. You will see there's some bubbles there you can click on, those of you that are in the chat box too. And as I broadcast the results, you will see what the majority of you have selected. So currently, as it's live action shifting, about 70% say state and county make the case decision together. So let's go back to the slides and have Mary discuss our case decisions.
All right. The answer to that polling question is number 2. The county is the one who would make the case decision on CPS assessments of a licensed foster parent. So again, case decisions on assessments of licensed foster homes are made by the county child welfare agency that completed the CPS assessment. When a family is notified of the case decision, the licensing worker should accompany the partner agency who completed the CPS assessment when the case decision is explained to the family. And after the family is notified of the case decision, their licensing worker should then explain to the family the possible implications of the case decision with their foster license and be able to answer any questions they may have. So if the case decisions are made by the county child welfare agency who complete the CPS assessment, why are these cases being staffed with a regional child welfare specialist with the state? The RCWS's role in the case decision is to make sure that the assessment is thorough and to ensure that counties are clear about the difference between licensing issues, violations, and true CPS issues. Years ago, counties did not staff CPS cases on licensed foster homes with the state, but it was discovered that foster parents were being held to a higher standard than biological parents, and foster parents were being substantiated on for licensing violations that did not meet the threshold requirement for abuse, neglect, or dependency. Because of this, policy changed, and CPS assessments on licensed foster homes now had to be staffed with an RCWS. At the time, they were not called RCWSs, though. So when scheduling a case decision staffing, the child welfare worker with the county and their supervisor and the regional child welfare consultant with the state need to be present at that staffing. If a program manager or program administrator can be present, that would be ideal. The county must ensure that 2 levels of personnel are present at the staffing because they are making the case decision at that time. Currently, Gail Trevathan is the RCWS who is staffing all CPS assessments on licensed foster homes. Counties would email Gail Trevathan and she schedules the staffing in the order that she receives the request. If more than one case needs to be staffed at the same time, then you would just make a note of that in your email to her. And the CPS staffings with the RCWS should occur after the county has completed a thorough assessment, discussed the findings of the assessment, and are ready to make the case decision, but prior to reporting the case decision on the 5104. So if a CPS report is received on a licensed foster home, unfortunately, it's more likely than not that the child will be moved or placed in respite. As I discussed earlier, some of the reasons that a child will be moved include the nature of the allegations, if there's a physical injury, if there is medical care that is needed and not being provided, if the supervising agency has an internal policy that they move children when a CPS report is made, or if the foster parent requests a child to be moved. But a full and complete CPS assessment is still required on these assessments, regardless of whether the child remains in the foster home or has been moved. This includes ensuring all children named as victims are seen and interviewing any children who may have witnessed the allegations but are no longer in the home. While it can be difficult to identify every child who may have been a victim or witnessed the allegations due to the nature of foster care, the assessment worker can ask other children who are in the home, who else has been in your home in that time frame. You can ask for the foster parents for a list of children in the home over the period of time of the allegations, or you can also ask the supervising agency for a list of children who have been placed in the home. It is so important to remember that moving a child will never negate the actions of a foster parent, and the CPS assessment should never be unsubstantiated simply because the child was moved and the child is no longer in the home and has no plans to return the home. And I will now turn the presentation over to Maria Lattimore to discuss the role of regulatory and licensing in CPS investigations on licensed foster homes.
Thank you, Mary. So we've heard a lot about regulatory and licensing and that they're in Black Mountain. So let's talk a little bit more about the role of regulatory and licensing. So the North Carolina Division of Social Services Regulatory and Licensing Section was created to oversee the licensing process for foster family homes, residential facilities. When I say residential facilities, I'm talking about those level 1 group homes, not mental health facilities, child placement and child placing agencies, and as well as maternity homes. We're going to focus our discussions more toward the family foster homes just for the sake of this discussion. So the North Carolina General Statute 131D Point 3A states that no person shall operate, establish, or provide foster care for children or receive and place children in residential care facilities, family foster homes, or adoptive homes without first applying for a license to the department. The department is defined as the Department of Health and Human Services. So regulatory and licensing developed rules that govern how foster care, family homes, and residential facilities are licensed. Those rules may be found in 10A, NC, AC, 70, E through L. It is the responsibility of the department, so regulatory and licensing, to determine whether there has been compliance with the licensing rules of the commission. And so we've talked a lot about notification, and now we're going to discuss why is it important for regulatory and licensing to receive notification. As Mary stated, not every CPS report will be substantiated, and there is a difference or distinction between licensing rule violations as well as from CPS substantiations. So it is important to note that not all licensing rule violations will amount to a CPS substantiation, but they could form a basis of a rule violation. So it's important to take into consideration if what you're seeing in a home might be a rule violation. So an example of how a rule violation differs for a CPS substantiation is an example could be the use of corporal punishment. So there is a strict prohibition against any form of corporal punishment for licensed foster parents. And you can see that in 70E. However, that may not create a CPS substantiation depending on the facts of the corporal punishment. Another example would be that a foster parent sending a child to bed without dinner. That would violate the client rights of the foster child pursuant to licensing rules. Again, may not be a CPS substantiation, but would create a problem would violate licensing rules.
All right, we have 2 more polling questions for you. Let me bring us here, hide our previous one. You should see questions 4 and 5. Number 4, if a licensed foster parent disciplined their non-foster child using corporal punishment, would this be a substantiation? Your answers are yes or no. You see the bubbles there that you can click on one. And number 5, would it be a licensing rule violation? Yes or no? So click on appropriate bubble. Once I see we've got a pretty good response, I will broadcast the results so you can see how your peers have answered this. And then Maria can discuss the answers. All right, I am going to share the first one. It looks like we've got well over 200 people responding. So you will see the majority of you, about 75% of you, believe it's a no. And if I broadcast number 5, would it be a licensing rule violation? It's almost split there. Almost about a 50-50 split. So, Maria, do you want to jump in and talk through the answers?
Thank you, Rick. So the first one, would a licensed foster parent who disciplined their child, their non-foster child, using corporal punishment, would this be a substantiation? And the answer is no. So it obviously just discipline a child using corporal punishment does not necessarily create a substantiation. Obviously, we're going to talk about degrees of if there was any physical abuse. That's a little different, but just like a regular spanking or something like that, that would not create a substantiation. We're talking question number 5. If that same scenario happened, would that create a licensing rule violation? And the answer is no, because it is the parent's biological or adoptive non-foster child. And so when you're thinking about foster children, you have to understand they have an extra layer of protection, which is which is client rights that are in rules. And here, the licensed foster parent is not violating any of those client rules against corporal punishment. So, in every foster parent has to agree to a discipline agreement, or sign a discipline agreement. Every child in foster care has client rights as outlined in 10A NCAC 70E 1101. And that was what I was referring to as the extra layer of protection for foster children. It outlines foster parents are required to sign a discipline agreement acknowledging and agreeing to clients' rights regarding punishment. Okay, foster parents shall initially, at the time and at relicensure, sign these discipline agreements, and they're specifically acknowledging that they won't do certain things to foster parents. And if you ever have any questions about it, a supervising agency shall retain copies of that. So some of the things that the 5 items that foster parents have to agree to is that they shall provide training and discipline that's appropriate for a child's age, intelligence, emotional makeup, and past experience. That they're not subjecting the child to cruel or abusive punishment as established in as 7B 101, 1 and 15, and that they are not they're not using corporal punishment on the minor child. They're also not depriving the minor child of meals or contact with family for punishment or placing them in isolation timeout, except when isolation timeout means the removal of a child to an unlocked room or area from which the child is not physically prevented from leaving. The foster parent may use isolation timeout as behavioral control when the foster parent provides it within a hearing distance of the foster parent. The length of the isolation timeout shall be appropriate for the child's age, intelligence, emotional makeup, and past experiences. And lastly, that they're not subjecting the child to verbal abuse, threats, or humiliating remarks about himself or herself or his or her family. So now that we've talked a little bit about the discipline agreement and some of the extra layers of protection for foster children, let's talk about if you have a situation and what does licensing and regulatory do once they receive these notifications. So some of the actions that licensing and regulatory can take is they can reduce a foster family's home capacity. In our state, the current state capacity is 5 children. There are some minor exceptions. But if there is a situation where a family foster parent is having difficulty managing 5 children, regulatory and licensing may reduce that capacity. They may require a foster family to have additional training and education. They may change the type of license. So you might have a foster family that's therapeutic that's now being changed to a family foster home. They can require foster families to complete services like therapy, parenting classes, anger management. They can also ask or have a conversation with a foster family and ask them to take a break from fostering at that time. And so that is a voluntary, a foster family could choose to voluntarily end their license, and we call that termination. So a family can terminate their license, which is voluntary. And then if the issues in the home are serious enough, the state may revoke a foster family's license. So let's talk a little bit about the revocation process. It is found in 10A NCAC 70E.708. And it states that the licensing authority may revoke or deny licenses when an agency authorized by law to investigate allegations of abuse or neglect finds the foster parent has abused or neglected a child. The licensing authority may revoke or deny a license when a foster home is not in compliance with licensing standards in this subchapter, talking about subchapter 70E. The licensing authority shall base the revocation or denial on the following. 1, a child's circumstances, a child's permanency plan, the nature of the noncompliance, and the circumstances of the placement. Foster parents shall be notified in writing of the reasons for the licensing authority's decision to revoke or deny any license. When the license has been revoked, foster parents shall submit their license to the supervising agency so it can be returned to the licensing authority. So when considering whether regulatory or licensing will, not regulatory or, will revoke a license, it is going to have to be based on the evidence because we have to go to court oftentimes. So evidence is required to revoke that license. Regulatory and licensing will request records of the county DSS, such as child medical evaluations, pictures, and we'll ask that those pictures are in color, investigation notes, and RIL placement information. It's really important whenever regulatory and licensing is reviewing substantiations or non-substantiations that if the allegation is regarding child abuse, sexual abuse, things like that, that we have CMEs or child medical evaluations. If there's a bruise that you guys are sending us and trying to show us that a child was assaulted that left a bruise, having that in color is just going to be more persuasive. So whenever regulatory and licensing contacts the county is authorized by law to provide the information to regulatory and licensing. And we find that permission or that ability under NCGS 7B 302A1. The department shall disclose confidential information to any federal, state, or local government entity or its agent or any private child placing or adoption agency licensed by the Department of Health and Human Services in order to protect a juvenile from abuse or neglect. And the reason for regulatory and licensing requesting the information is to protect not only that juvenile that may have been removed from the home, but additionally future children that may be placed in a license placement. So next, let's talk regulatory and licensing will, in addition to collecting information from the county, it will also collect information from the foster parent. They're going to talk to the foster parent, ask them for a statement regarding what the allegations were from the incident. They're going to contact the licensing or the supervising licensing agency, whether that's DSS or a private agency, to request a discipline agreement because a lot of cases are regarding unsafe discipline. They're going to request agency notes and contact information, quarterly note visits, and training records. When considering a decision, the licensing and regulatory section will consider a lot of factors. Some of them are listed in .708 of the Administrative Code. But that's the child circumstances, child's permanency plan, the nature of the noncompliance, and the circumstances of placement. Some of those factors may not necessarily be as pressing by the time licensing and regulatory receives the referral because oftentimes, as Mary stated, the foster child is relocated. The foster child may no longer be in the home. Licensing and regulatory will consider the severity of the rule violation, the frequency of the rule violation, and whether the noncompliance can be corrected by other mechanisms. Once regulatory and licensing makes the determination to revoke a license, they will send out a letter as required by the administrative rule to notify the foster family that they are revoking the license, their intent to revoke the license. The foster parent has 60 days from the date of that letter to appeal the agency's decision. The revocation is not effective until the 60-day appeal period expires. So should the foster parent or foster family appeal the intent to revoke letter, then it will go under judicial review. So actions by state agencies are reviewable by the Office of Administrative Hearings, or OAH, and that is pursuant to North Carolina General Statute 150B-23. State agencies are defined as an agency or an officer in the executive branch of government of the state. The term includes a council of the state, the governor's office, a board, a commission, a department, a division, a council, or any other government that in the executive branch. And it specifically states a local unit of government is not an agency. So county agencies are not state agencies subject to the Office of Administrative Hearings. So OAH was created to protect citizens from governmental overreach. So it's important to understand when regulatory and licensing it has decided to revoke a license, that is considered governmental action, and constitutional protections apply to those agency decisions. Citizens are entitled to procedural and substantive due process. So when I say procedural due process, what we're talking about is the citizens' right to appeal the decision of the state agency, to have a hearing, the ability to review the evidence. So sometimes if we receive things from the county, whatever information that we receive in order to make the decision to revoke, at that time the citizen would be able to review that information in order to prepare their case. They also have, when I say substantive due process, what I'm talking about is the protection of the actual right of life, liberty, and property. So it has been determined by the North Carolina Court of Appeals that parents, individuals have a constitutional protection of a liberty interest in caring for children, and that's inclusive of fostering foster parents. So. In the Office of Administrative Hearings, the agency decision will be overturned if the petitioner, which would be the foster family, can show that the agency has otherwise substantially prejudiced the petitioner's rights and that the agency did the following. And that would be exceed the authority or jurisdiction, acted erroneously, failed to use proper procedure, acted arbitrarily or capriciously, or failed to act as required by law or rule. So I want to just focus on the acted erroneously. That's why a lot of times the licensing and regulatory will request additional documents, interviews, CMEs, pictures, because we want to make sure that we have the information correct and that we can present to a court all of the factors so that the court can see that the licensing and regulatory did not act erroneously or in error. So at this time, we're going to revisit the case scenarios for our conclusion, and for that, we'll go back to Mary.
All right, so now that we have discussed the nuances of CPS assessments on licensed foster homes, the role of regulatory and licensing, we are going to revisit our original case scenarios. So just to recap, case 1, we have Clyde, 8-year-old boy in foster care, had reported that his foster parent hit his legs and buttocks. He didn't have any marks or bruises. He was removed from the foster home, and after his removal, a CPS report was made. The CPS report was accepted, but unsubstantiated, and regulatory and licensing was never notified that there was a CPS report on the foster home, nor were they notified that there was a case decision. In case 2, this was 6 months later. Thelma and Louise are our 3-year-old twins. They were placed in the same home that Clyde had been removed from. Our twins attended daycare, were not yet potty trained. So while the daycare worker was changing Thelma's diaper, they noticed marks and bruises on the child's legs and buttocks that were not present on the child the day before. And the CPS report was made, and this CPS report was substantiated. So when reviewing Clyde's case, regulatory and licensing was never notified that a CPS report had been made on the foster home, and they were never notified that there was a case decision. Now, why is this so important? So regulatory and licensing staff review every single DSS 5282 that is sent in, and that notification is placed in the foster parent's licensing file with Black Mountain. So if regulatory and licensing had received the required notification, the following steps would have been taken. First, the licensing consultant with the state would have reviewed the allegations and the case decision. Because of the nature of the allegations, even though the CPS case was unsubstantiated, the licensing consultant would have then completed an independent investigation to determine if the foster home had violated any licensing rules. This investigation would have included requesting records from the supervising agency, sending questionnaires to the foster parent, and these are just a minimum that would have been done. And regulatory and licensing would have then staffed the findings of that independent investigation to determine if any licensing restrictions or negative actions needed to occur. So this could have resulted in those twins never being placed in that foster home and being subjected to the abuse or neglect by the foster parent. So what makes CPS investigations on licensed foster homes so unique and so important is that your investigation, your case notes, your pictures, your attention to detail and policy can affect the outcome and treatment of every single child that could be placed in that licensed foster home after previously been removed from their family because of abuse, neglect, or dependency.
So, Mary, we have a couple of questions. So one of them was by C. Rogers, says that I just learned in pre-service training that foster parents are not allowed to perform corporal punishment on a foster child at all. So why is that not a violation? Was this incorrect information given to us? So I think that that Rogers is referring to the question, that the polling question, and that was corporal punishment on a non-foster child. So you're correct. Your foster parents are not allowed to use any corporal punishment on foster children. So hopefully that clarifies. Mary, we also had a question. Can you please explain what qualifies as a conflict of counties relating to licensed foster homes? What county supervises the family and victim child being in foster care in that county? I've come across several counties who believe a child in their custody placed in a foster home they do not supervise say this is a conflict when other counties do not consider this a conflict. The chart in the manual is not clear.
So I can try. I will say that this is definitely one that we will address in our follow-up notes. But there is, of course, in the policy manual, it says that a DSS director can determine other factors that they would consider a case to be a conflict of interest. But typically, what would happen is if the DSS has custody of the child, that DSS should not be completing that investigation if that child is placed in a foster home that county also supervises.
Okay. We have another question. It says, we can still use the partnership development plan for non-CPS violations.
I actually don't know what a partnership development plan is. So if Denny McBride could maybe put in a little bit more information about that, that would be fantastic.
And Sabrina Huggins, is a revocation high in North Carolina in comparison to other states? I'm not familiar with what other states are doing. However, I would say that in North Carolina, it is not high. I think that we definitely want to look at that, and we are developing processes so that we can pay more attention to the CPS violations. We definitely review those, and we definitely take actions, but we do not always revoke. So we do pay attention to CPS substantiation.
So it looks like the next two questions are similar about whether or not in our scenarios, how scenario one has, if the case was accepted as a report, that's just a screening decision. without going into a whole lot of information about what might else have been in that CPS report. But we can discuss that more in our information that we send out.
And I believe that it says, can we ever find out what happened with regulatory and licensing regarding foster parents of a child that was unsubbed? Typically, well, it just depends on what the county's relationship is to the foster parent. So if it was your child that was placed there, you'll probably know. Because if you didn't move the child will, if they continue to have their license, the child will continue to remain there. If you're the supervising agency, as DSS, you would know because licensing authority does communicate with the supervising agency. So it just depends on your relationship to the foster family.
All right. It looks like Tracy did give a little bit more information about the partnership development plan. And yes, so the partnership development plan could also be used by the agency who supervises the family to talk about the non-CPS violations.
We do have a few more minutes. If you want to continue to type any questions you have into the chat box, we are capturing them. Those that they are not able to answer at this time, again, our expectation is we will send out a follow-up question and answer document to all registered participants. This document will also be posted online with this recording. So please type your questions in the chat. We'll try and answer a few of them now.
So Kayla Lee, yes, that's what happened. So if the licensing authority revokes a license, all the foster parent has is 60 days. If they try to appeal after the 60 days notice, it's not effective anymore. That's the only time that they have. And they may try to reach out to contact people in order to get a new license or to be reinstated.
And if a foster home license is revoked by the state and the family does not appeal, or if they appeal and they do not win, then the revocation on their license is valid for 5 years that they would not be able to become relicensed for.
So what should we say then? So, I think that one of the things that when you're talking to foster families is, depends on your relationship to the foster parent. Are you the supervising agency? If you're the supervising agency, you can just explain how the licensing process works, and that if they did not appeal in a timely manner, then at this point, the revocation is effective, and it will be effective, like Mary said, for the duration of that revocation. So, Mary, we have another question. It says, what are licensed social workers' responsibilities during, after, an assessment on a licensed foster home?
Absolutely. So I am going to be brief here just because we will go into a lot more information about this in our information that we send out after this. Of course, the licensing social worker will be notified that there is an assessment that is being completed. The licensing worker will actually most likely hear from somebody from regulatory and licensing to discuss the allegations, to discuss if any preliminary things need to be discussed. Does there need to be a temporary hold on the foster home, not have any children placed in that home during the CPS investigation? Of course, the licensing social worker needs to be able to support the foster family. That is one of their main roles. They would definitely need to encourage foster families to cooperate with the CPS investigation. We do see that doesn't always happen because foster families are not happy that a CPS report has been made on them. And then, of course, after a case decision is made, then the licensing worker, we would expect that they would continue to work with regulatory and licensing, especially if a case is substantiated or if a rule violation is found, to determine what types of actions need to happen, whether that's additional training, whether that is, let's talk about whether or not you should still be licensed, or is this something that rises to the level of a revocation? And that is something that the licensing social worker for the family would be involved in.
So we have a couple more questions. One of those is, if a foster parent appeals the RIL and wins on appeal, could their license still be revoked? And the answer is it could, but not on the same basis. So let's say the RIL would be about serious abuse or serious neglect. That would be the standard. But let's say that there was something else that was going on in the home that was not addressed in the court, in the RIL hearing, that may give rise to a violation. Then we're not prohibited, licensing and regulatory is not prohibited to the other violations that were not discussed in the RIL hearing. There was another question about, can the family relicense in another state after revocation? That will be dependent on the rules and the statutes in that other state. So I can't speak to what they will be able to do in other states. And then there's another follow-up question about, are we able to speak to other licensing agencies while the cases are substantiated? So I'm not really sure. Are you talking, Kayla, about if you're talking about supervising agencies? So supervising agencies would not be substantiating CPS cases, so that would just come from the county. And so as a supervising agency, you can definitely have a conversation with the other county, but it shouldn't be to interfere or influence with the county who is assessing and making the determination on the case. That is up to the investigating county to determine whether the CPS case will be substantiated or not. And then from there, then it's regulatory and licensing's role to make decisions about what will happen regarding their license. So I hope that clarified your question. We have another question. Can you, Mary, can you please explain why Clyde's report was a screen in? The allegation seems to only be using corporal punishment. This is a licensing violation, no marks or bruises, so it is unclear why the report became an assessment.
Yeah, so for that one, those were the big highlights. So there would have been more information in the report that would have allowed the report to be screened in. Excellent comment, Denny. In case anybody has not seen it, they wrote, it is so important that we as the licensing worker are making certain that we are following up with families, former agency, and that we be open and honest so that another child is not placed in a home where there may be risk to a child in care.
Let me see. So what are the ramifications for private agencies when they continue to place children in homes with an open CPS report but does not let the DSS know that? We are seeing this more, and we had some alarming instances, and we did let the state know of these instances. Some private agencies say they weren't notified. It is very concerning. Melissa, I think that's something that's we're going to have to dig into that a little bit more. Regulatory and licensing definitely oversees private supervising agency. So that's something that's a little bit more fact intensive, and is going to be something that we would just have to look into based on the actual the facts. But that is something that regulatory and licensing does pay attention to trends even in private agencies.
And just to go back a little bit, we did talk in the beginning of the presentation about that the agency who supervises the foster home is required to be notified within 2 hours of a CPS report. So if a private agency is saying that they have not been notified, then obviously that is super concerning that they don't know. And of course, if regulatory and licensing receives the proper notification, then our consultants actually reach out to the private agency to discuss the report and the allegations. All right, so we've got if foster care parents have a substantiation for their foster care children, do they also receive a substantiation with their biological children as well? So this would depend on specifically what the allegations are and what the findings were for the CPS investigation. Sometimes we see that everybody in the home there is a substantiation. Other times it is some of the children yes, and some of the children no.
So how much information is provided to the supervising agency in that notification? So the supervising if you're referring to the notification that happens initially at the time of the CPS assessment, that's going to be determined by whoever the county that receives the report, what they tell the supervising agency. If the decision is, if the notification that you're referring to is what regulatory and licensing does, regulatory and licensing is going to send the supervising agency information if we're going to take negative action. But if they're talking about a second notification, once CPS has made their determination, that will again be a county notification, what the county tells them.
All right, and we will take a couple more questions. I think we'll go to 11:10, 10 after 11. So the next one is, sometimes we don't know at intake if the person is actually licensed and who that agency is. It is helpful to know that we can check with regulatory in real time to get that information. Is there a certain person or number that we should call for that purpose? It is actually the general number. We have a consultant that is actually on call that would take those phone calls. If they happen to be on another call, then they will actually get back to you and get that information.
So, Sylvia, you're asking a question about what happens when respite care providers have a case for sexual abuse, but the case decision has not been determined and other children are placed in that respite care. I think that is bad practice for the supervising agency to place children in a home while there is a pending investigation, especially regarding sexual abuse. So that's something that I would definitely encourage you, if you're a licensed person or if you're a CPS investigating it, to let them know, hey, we have an open case on this house, or let the state agency know. So that's something that I would think that somebody needs to have a conversation with them about the safety of the children that are currently in that home while there is a pending investigation. What happens in regulatory and licensing, we are not allowed during the pendency of an investigation to take any negative action at that point. So just the fact that there is an investigation, so think of it as an allegation. There is an allegation. There has to be a decision one way or the other. And after there is a decision, Then that information gets to us, and we are required to do a separate independent investigation. We can use that child medical evaluation and some things like that. So there's not going to be a hold on the license, because once the regulatory and licensing actually take action. So to put a hold to reduce the capacity to zero, we are then acting, and that is when the person gets to appeal. And so because the investigation has not concluded, that would be premature. So we just rely on people to tell each other. That's why notification is really important, so we can make sure that children are not being placed there in the interim.
And just to kind of follow up on that, while the state can't take action, the supervising agency can make a decision with the foster parent to not have any children placed in that home while the CPS investigation is occurring.
And that's what we encourage at the state level.
Absolutely.
I am not seeing any more questions at this time. Let me show you who you can contact. I say that, and here comes one right now. Might have time for just one more as I show our contact information slide real quick here. If you want to jot down Mary's contact, of course, our foster home licensing manager, Jenny Millsaps. There is the number to the regulatory and licensing office, and of course, check with your regional child welfare specialist. So we have time for maybe one more question, and then I will go over some final next steps for you so that you can get credit for attending this webinar today.
All right, so it looks like our last question is coming in from Cabarrus County. If there are other children in the home during the investigation, are they removed as well? That is a great question. So the state does not encourage children to be removed necessarily from the home during an investigation. Obviously, that depends on the nature of the allegations. But we do know that a lot of times that foster parents will request a child to be moved. There is no rule that says that if one foster child is removed, that another foster child in the home has to be removed either. But we will definitely provide more information on that on our talking points.
Great. Thank you, Mary, and thank you, Maria.